Good afternoon. This is the House Judiciary Committee. It's April 4th, 2024. And everyone, we have some concurrences which aren't on your list that I need to go and rattle through. Okay. Well, you like the first one then. House Bill 105. House Bill 105 is Delegate Atterbury. Her bill on the interlock. When we last left our show with the interlock, we sent a bill over that did not include expungement, but did include a change in the interlock statute that would basically say that from when you started the time of the interlock would be when the 180 days started. So in other words, you wouldn't get a double. There would be no chance that you would get 180 days because your license was suspended, then 180 days at court. That was not in the Senate version that was passed over here. So what the intent, at least what my proposal is that we not concur, appoint a conference committee with the goal of including that language that just says that you can't double up on the length of time that somebody gets the interlock. So they get the 180 days for interlock for a PBJ. They're going to get 180 days, whether it begins prior to trial or whether it begins after trial. That would be the goal here. So I would make a motion not to concur and to appoint a conference committee. Is there a second? All right, so we're going to not concur and appoint a conference committee. All in favor of not concurring, please raise your hands. All right, anybody opposed? All right, that's adopted. I don't have anything else to do. I'll make myself chair of the conference committee. Well, that's a really, really good question. I don't know. It's a valid question. Valentine. And with no offense, Valentine, former police officer, maybe has done a DUI in his life. One or two? Okay. All right. That's fine. And Embry. Because she hasn't. All right.
One needs their first conference.
House Bill 404. House Bill 404. This is a bill from Delegate Woods, and Delegate Williams has been working closely with Delegate Woods. And I believe Delegate Williams, you would like to not concur in the Senate amendment.
We are not concurring with the Senate amendments.
All right, and a second. Any discussion? Their amendments are something to behold, but I send it over to Delegate Williams to try to describe.
So I believe the Senate amendments remove fire, EMS, and law enforcement.
I'm sorry, let me get that again. So in order, so the bill has to do with wellness checks and making sure they happen. And so the Senate amendments would remove police, fire, and EMS. Delegate Williams has not responded, but has smiled. All right, we're gonna not concur. That sounds great. And all in favor of not concurring, raise your hands. I've seen it all. 1, 2, 3, 4, 5, 6. Anybody opposed? Nobody's opposed. We're not concurring in the Senate amendments. All right, we're gonna appoint Williams one more time for Valentine. What? We were gonna put Crutchfield on, but I don't think she'll mind if Kaufman. All right. Kaufman. Williams, Valentine, and fight a little more than least get the EMS back in or something like that. Literally no one in it, I swear. All right, the painful saga of the Dorchester County delegation's polygraph experience has been it's been pretty exhausting, actually. But I think we're concurring this. Oh, we need the delegation. Oh, the bat signal has come up from the Dorchester County delegation, and we are ready to concur in the committee's amendments. All right, everybody. Does anybody have any question? And they made a change, and one of the changes was the one that we already added onto the bill. Another was made on the floor from Senator Kagan. Okay, just stop, be nice, stop. It changes center dispatcher for 911 and makes it a specialist. I am going to the bill, and that's what it does. That's exactly, it changes it from a 911 center dispatcher to a 911 specialist. My understanding is that on this local bill, the Dorchester County delegation is fine with this. And we have a motion to concur in a second. Any further discussion? All in favor of the motion to concur, please raise your hands. We're moving to concur. Moving to concur. Anybody opposed to the motion to concur? One. All right. Two. Okay. We have moved to concur. God. All right. House Bill 583. The Senate added amendments. This is the bill creating a Center for Firearm Violence Prevention, and they added in the bill that, where is this in the bill? Let's just make sure we have it in the right place in the bill.
We've already made the change.
We made yeah, so we're basically conforming the bill to what we passed out on the Senate bill. And I think it basically
adds more individuals.
Yeah, it adds more, yeah, that's what it does. It adds more individuals to those groups that the center can confer with, and adds individuals or organizations with an expertise in firearm safety and training. That is what it is. It's consistent with what we did. There's a motion to concur. Is there a second? Second, it's been heard. All right, any further discussion? Sounds great. All in favor, raise your hands. Anybody opposed? Are you still voting for it, Madam Vice Chair? Okay. The motion to concur is adopted. Moving on, Delegate Taylor's bill, House Bill 1037. We amended Senate Bill, the crossfile, I think, and there are amendments that they put on to your House bill. I believe that we conformed. This is a technical amendment, I think, right? Right, Claire? More or less. Let me find the place in the bill just so that we're making sure that we're doing something right. On page 553, line 19. So it's making a reference to, I think, to health services that happen on or after June 1st, 2024. Is that correct?
It's the meeting.
Oh, okay.
At the first meeting after the code of conduct. And
okay.
The first meeting after June 1st. Is that the second date?
Okay, so that's the first meeting they have to adopt a code of conduct, and that has to happen after June 1st. So so the motion I think here is to concur with the Senate amendments. I don't think there's an issue with that. Looking at Delegate Taylor looking quizzically back at me. We did on the Senate bill. I think we're just conforming the House bill to look like the Senate bill at this point. Okay. Not exactly.
I don't think we did this.
Sorry?
Let me look it up.
All right, Claire's gonna look at this and make sure we're not putting this in some weird posture. So we will come back to that in a moment. House Bill 832 There are amendments that we already adopted on the Senate bill that include,
No, we haven't. This is just the preamble to match it.
okay, so the difference between the House bill and the Senate bill is that they included a preamble. Well, it's always the chair's really favorite thing to see a preamble, but here it is. It does nothing to the text of the bill. So I would make a motion to concur in adding the preamble to the thing. There's a second. Is there any further discussion on the preamble that they've added to this? All right, all in favor of concurring with the Senate amendments, please raise your hands. 2, 3, 4, 5, 6, 7, 8, 10, 11, 12, 13, 14, 15, 16, 17. Anybody opposed? All right, we have concurred in the Senate amendments. We'll keep going. Quite a few concurrences. All right. House Bill 585. Protecting Election Officials Act. This is an administration bill. It's an administration priority. The Senate added amendments. That this is the election pages. They added them to the House bill.
Didn't we take those out?
We did. So there's a motion not to concur. Is there a second on the motion not to concur? Well, all right. So the motion is not to concur. Now we'll have a discussion as to whether we want to go to war about election pages. Delegate Williams.
I don't. From my understanding, the reason we removed election pages was because the pages are not actually handling they're not physically handling any of the election materials. My understanding is that the role of the election pages is just simply to observe and to learn because they're high school students.
Okay. So
Makes it the same with the Senate bill, which is.
And so
Okay.
I don't know if it's worth the fight, but I just, wanted to say that.
all right, Delegate Phillips, then Valentine.
So, Mr. Chair, I understand.
585.
I understand the idea that from our perspective, we think this is a little bit much. At the same time, we're now a few days away from sine die. Adding pages in my mind does not take away from what our intent is as a body to ensure that election officials receive the appropriate protection. And I would argue that we not send this back over. That would be my thought.
What fun is it being a responsible adult these days? Delegate Valentine, did you want to say?
Asked and answered.
Asked and answered. Delegate Williams.
Did they keep the provision in there with regards to the council
Yeah, I think so.
and attorney general that we added to our version?
I
Mr.
believe
Chair?
they did. Did they add the Board of Election Council? One moment, please. Delegate Cardin, while she's looking at that.
So just to reiterate what I think Delegate Williams was trying to say, the pages by definition are not employees, right?
No, they're not.
And so they're not paid, they don't have any benefits, and there's probably a different degree of liability that is held by the offices on those people. Seems to me that this is just setting us up for the potential for a conflict of, I wouldn't say conflict of laws, but a conflict of litigation availability and possibility should anything actually happen. I think it's a bad idea to have pages. I just think they need to be included at a later point. It's an easy legislation in the future, but again, this is certainly not a bill to fall on any swords on. But if they did remove counsel, I would say
That is an issue.
that's an issue.
I don't believe that they took out council. Okay.
Okay.
Council is still in. The motion before us is a motion not to concur, and people have made reasons and thoughtful arguments, which of course are welcome at this point in session because, you know, it doesn't really happen very much now. But having said that, here we are. Look, the chairs. It's an important bill. It's an important bill, and it's a bill that we need to, that we do need to act on. I don't really want to hang it up over something small at the same point. At the same time, I don't generally disagree with the argument that reaching all the way down to pages seems excessive. And so that's kind of why we did this in the first place. The question is here on Thursday at a little after 3, whether we want to spend more time on this or not. And for that reason, I'm not going to take a position. Decide what you want to do. Welcome to your first jump ball committee. It's going to be a fun time for all of us. The motion is not to concur. So if you want it not to concur, then you're going to vote yes. And if you vote not to concur, we'll appoint 3 members of a conference committee. We'll send it over right away. If you vote to, if you're against that motion, fine, then we'll come right back to a motion to concur right after. Delegate Tolles.
I was going to remove my motion not to concur or amend my motion.
All right. So I think, I mean, this, where we are is on a motion not to concur. We're gonna roll it this way and see where we are. I take no position. Let's see what happens next. What could go wrong? All right, the motion is not to concur. All in favor of a motion not to concur, please raise your hands. 1, 2, 3, 4, 5. I can't tell what Delegate Simmons is doing. 6, 7, 8, 9, 10. All opposed to the motion not to concur, please raise your hands. Dreading what's about to happen next. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Hooray. All right. 11 to 10, the motion not to concur is not agreed to. The motion then therefore becomes a motion to concur. All in favor of the motion to concur, please raise your hands. 1, 2, oh boy. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Oh boy. All opposed. 1, 2, 3, 4, 5, 6, 7, 8, 9. 11 to 9. I need 13.
Oh, God. Oh.
So we've done none of the above. So it didn't succeed, didn't fail. So we're gonna come back to this.
Everybody wanna reconsider.
Delegate Moon, let's ignore Delegate Erican for a minute. Delegate Moon. Delegate Moon.
I'm gonna throw in the towel. So as much as I believe, oh,
What do you want to do?
Wait a minute.
Feel the spirit of Joe Valerio, by the way, in the room right now. I just want to let you know. Delegate Moon.
I don't actually feel strongly enough about this, so if you guys want to vote today.
Do you have a motion that you want to make? You want to reconsider the vote on the,
Oh, is that how we would do it?
or bring it back tomorrow?
No. I'm gonna move to reconsider the vote on.
A motion to reconsider in a second.
Can I say something?
Yes.
I will just say, I understand what everyone's saying about pages, but I will say that immediate family members of these election
enough.
officials are included. And immediate family members neither take an oath, neither are employed, neither, they don't even work down at the poll site. So just keep that in mind. So that's the reason why I am okay with concurring in this instance.
Okay, so the motion is to reconsider the vote. All in favor of reconsidering the vote, raise your hands. Oh, did Thompson, who had a question?
Tom,
Sorry, Delegate Tomlinson, you got.
Do we need vote to then have discussion or?
Yeah.
Okay.
All right, so we're gonna go back to the bill here in a second. All in favor of reconsidering, please raise your hand. Chair would ask you to reconsider, please. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. The chair votes 13, 14 to reconsider. All right, we're back on the question now as to what to do with House Bill 56. There's a motion to concur in a second. Now we'll have discussion. Delegate Tomlinson. This is fun for everyone out there too, I'm sure. It's great. Delegate
Do we have
Tomlinson.
actual bills to vote on? No,
Yes.
No,
Me too.
okay, just to confirm, if you vote to concur, you're agreeing to keep the pages. Okay. Okay.
Means you're keeping the pages and prints against the pages. Okay, there's a motion to concur in a second. Here we go again. All in favor of the motion to concur, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11.
Oh, God.
Are you serious?
Somebody switched. Two people switched. Oh, Grandma left. Grandma left.
He was voting no. All those opposed, raise your hands. 1, 2, 3, 4. You voted yes, Simmons. You voted yes. 5, 6, 7, 8. We're coming to this tomorrow and we're going to figure out how to deal with it then. Thank you all very much for being here today. It's great that you're getting to watch us at our very best here. Holy cow. Okay, well, that was fun. So let's do there's a motion to concur then on House Bill 732, which is the endless and never-ending referendum bill regarding the Baltimore City Police Department, which I'm very excited to finally get out. It concurs to, shut up. It concurs it concurs with the Senate bill. I make a motion to concur in the Senate amendments and a second. Anybody have any discussion? I didn't think so. All in favor to raise hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Anybody opposed?
No.
Great. Motion to concur is adopted and the Republic is secure. All right. Now back to House Bill 1037. Who knew that the concurrences were going to be this much fun? Claire, you're saying that it's putting it in the same posture that we passed the Senate version of this bill. So it's concurrent, it's putting it together in the same place as what the Senate bill that we already passed. So we're putting it all in the same posture. That's why I would make a motion to concur. And a second, Delegate Taylor.
Thank you, Mr.
Hold
Chair.
on your mic.
Pull down your mic so we can hear you.
I had that amendment when we voted before, so I'm
So
not sure why
they added it on to your bill in the Senate. We're just concurring with the Senate and getting your bill across the line,
okay.
unless it really goes down in flames on the floor. Okay, great. All right, all in favor of the motion to concur, raise your hands. 1, 2, 3. Are you voting for this, Cardin? 4, 5, 6, 7, 8, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 20. All right. Motion to concur is adopted. Good God. All right. Love you all very much. Now we're going to go over to the voting list. We'll start with the cross file for the firearms bill that was Delegate Phillips' bill that's on the floor right now. There's
It just conforms.
right, so it's conforming it to the House bill, which means that we're adding the city solicitor and the county offices of law, county attorneys to the bill. Okay, so there's a motion on the amendments and there's a second on the amendment to add that. Discussion on the amendment that would conform it to the bill that we passed. Delegate Robertson, are you asking a question? Go ahead.
Thank you, Mr. Chair. I just know that the bill was held over from the first session to the second session, and we're expecting additional amendments. Is this one of those amendments that we were expecting?
No, this is the bill. This amendment just puts it in the same posture as the bill. It puts it in the same posture as the House bill that we passed a couple days ago.
Got it. And do we know what those expected amendments are?
It's a mystery.
Okay, I just wanted to
No,
check.
Delegate Phillips may know, but you
Thank
can, but those, yeah, I mean, I don't think we're gonna adopt any more amendments right this second unless somebody has some more for the Senate bill, but go ahead.
So there are a couple of amendments that we're anticipating. The minority leader has been kind enough to at least share one of those amendments that has been drafted. And it would change some of the language, and that language would make it very narrow in terms of causes for which a action could be brought. So we will deal with that on the floor. And then there's a potential for another amendment. I won't mention that until I actually have it in hand.
Thank you.
Purposes right now, it puts it in the same posture as the way it stands on the floor right now. All in favor of this amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. Anybody opposed? 1, 2, 3, 4, 5, 6. I just was giving him the chance to do that. So the bill is amended 15-6. So there's a motion for a favorable amendment and a second. All right, we're on the bill as amended. Again, it's conforming it to the House bill. Are there any questions? Any comments? Seeing Delegate Roberson.
Not only for me, but just for the public and processes wise. If I'm correct, if this bill had passed out of the House this morning, you know, we had, because it was second reader this morning, am I correct?
Second reader and was special ordered to the afternoon.
Okay, for another second reader.
So for process purposes, if when this passes, it's got to go to Senate rules. The Senate bill, if it passes the House, would go because we've made an amendment, it would go to the Judicial Proceedings Committee for them to decide whether they want to concur with our amendment or not.
Got it. Thank you.
All right, I think I got that right. Yeah, right. I got it one time a day. All right, any further questions? All right, we'll go to the roll call. The Vice Chair?
Yeah.
Yes. Crutchfield? Yes. Cardin? Yes. Sample Hughes? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons? Yes. Boucher? No. Phillips? Yes. Roberson? Yes. Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Moon? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Yes. Motion is adopted. All right. Yes. You want to change your vote on 488?
Let's be correct.
Okay, it will not change the outcome.
Right, right.
So
I
motion to
understand.
allow her to change her vote from yes to no. Anybody object to that? Second.
Yeah, I want to be
and
consistent.
We'll allow her to change her vote from yes to no. The motion still has favorable 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. 15-7. Yes, I can add 15-7. Okay. Senate Bill 623. Senate Bill 623 is the cross file for Delegate Ampre's bill, which we had on the floor today and passed second reader. Is there a motion? There are no amendments still to this bill. There's a motion for a favorable. Is there a second? And a second. All right. Any further discussion on Senate Bill 623? All right. The Vice Chair. Yes. Crutchfield? Yes. Cardin? Yes. Sample Hughes? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Oh, Tomlinson? Yes. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Yes.
All right. Roberson on Senate Bill 623. It's the, yes. All right. Now, blast from the past, House Bill 667, which we heard possibly when dinosaurs roamed the earth years and years ago, it seems like at this point. Are there amendments to there are conforming amendments to put it in this? Okay.
Formal.
Delegate Embry, why don't you tell us what
Could
the
I-
amendments, would you please? Thanks so
Thank you.
much.
Thank you so much. If I could start with Senator West's bill, is that all right? Just for explanatory purposes. Okay. There's language that was added in a floor amendment to exclude farm and domestic animals, or excuse me, to limit the section of farm and domestic animals. And that was out of a concern that oysters or fishing and hunting would be impacted in some way. And so I talked to Senator Bailey, whose amendment it was, and to Senator West and to the sportsman organization, and explained that there's already a section 10603, which excludes from any prosecution animal husbandry, animal research, and also hunting. So what we did is amended with their input and consultation and approval, amended that to add to hunting, fishing, and anything regulated by the natural resources article. Senator Bailey and Senator West are comfortable with that. So we would be amending the Senate bill to remove that farm and domestic animal phrase and replace and add instead language in 10603 clarifying that fishing is included. Thank you.
Motion to move those amendments and a second. Is there any further discussion on the amendments as described by Delegate Embry? Seeing none. All in favor of the amendments, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Anybody opposed? Seeing none, the amendments are adopted. We're on Senate Bill 17 as amended. Is there a motion? There's a motion for this is your line. Yes, okay. So there's a motion for a favorable and a second line. All right, great. Any further discussion on the bill as amended? Delegate Taylor, please.
Thank you, Mr. Chair. So can you explain to me again how this works?
So the reason for this bill is there was an interpretation by the Maryland Sentencing Commission. So in the sentencing guidelines, if you have multiple victims, your sentences are stacked, meaning the lower end is the same, but you're exposed to a higher doubling of the high end. These are discretionary, non-binding guidelines, but they do give input to judges about where they should land for sentencing purposes. And the Sentencing Commission determined that under Maryland case law, animals are not victims. Additionally, some judges are merging counts where you have multiple dogs or usually it's house pets, but sometimes it's not, being tortured or hurt in some way. And the judges were merging the counts in some cases incorrectly, but in some cases consistent with the law. So the bill does two things. It says if there's multiple animals, they are considered as separate victims for purposes of the sentencing guidelines, and the counts don't merge. They can still run concurrent. It doesn't mean anyone gets a higher sentence. It just means that the animals are considered legally as separate victims. And so that sentences have to consider them as separate victims. So that's the purpose of the bill. And the concern raised in the Senate was just making sure that we're not infringing on normal hunting, fishing
I
practices.
understand. So you said they will run concurrently, or
They
they will
could.
not? They could.
It could be consecutive or concurrent. It doesn't speak to that. It just means that the court has to consider animals as separate victims if they're, tortured or in some way.
Thanks.
Thank you.
Delegate Embry, there was one thing you said. I was good until you said the
okay.
one thing.
Uh-oh.
So the bill, does the amendment, the bill as amended now gives animals are included as victims in the definition of victim, or is it only under animal cruelty law that they're being counted as one victim in the general sense of what a victim is.
So this is limited to the animal crimes
Mhm.
in within the criminal law section, section 10. And so for purposes only of the sentencing guideline, the stacking function of the guidelines, they would be considered as separate victims.
Okay, so I'm looking at Delegate Moon because I think this touches on what the Sentencing Commission was talking about, that they needed, or that some folks wanted to be able to do that. Okay, all right, I think I understand. As long as it doesn't change the definition of what a victim is, I'm okay
No,
with it.
that's why
Okay.
we limited it to this section and to that
Okay,
language.
okay, thank you.
Further questions? Chair.
Yes.
Yes. Crutchfield.
Yes.
Yes. Cardin.
Yes.
Yes. Sample Hughes. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes, you can't add to a Senate bill, but good try. You have to run for a different office if you want to do that. Yeah. You'll be able to do that in a minute. You'll be able to do that in a minute. That's fine. And putting you on notice to in a minute. For the House bill, I suspect we'll have some ads. All right. Delegate Simmons. Yes. And why would you want to do that anyway? Anyway, Delegate Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Yes. Motion is adopted. We can't do the special thing with the thing and the unanimous consent because there are amendments on the next bill. So House Bill 667, which is Delegate Embry's bill, there are amendments now to conform it to look like what we just passed. There's a motion for favorable on that. And second, is there further, you don't have to describe them again. Are there further discussion on those amendments? Seeing none, all in favor of the amendments, raise your hands. 2, 3, 4, 5, 6, 7. Anybody opposed? All right, we're on the bill as amended, making it the same bill as what we had before. There's a motion to, by unanimous consent to make the votes from the votes from Senate Bill 17, the same votes as for House Bill 667. Is there objection?
No, but I like that.
Oh, yeah, we do have that as an issue. All right, if you would like to add on, please raise your hands.
Aaron, you're already on.
Does anybody else want to, Delegate Schmidt, did you want to add on? Delegate Schmidt wants to add on. It's upside down. Okay, good. Conaway wants to add on. Valentine wants to add on. Anybody else? All right, so we'll do those three as well, but this vote for the previous bill, Senate Bill 17 is going to be the same vote as 667. Great. There are 4 child support bills. I'm sorry, I'm going to jump right over them because I want to get rid of some other stuff here. Not really get rid of it, but I want to address it so that we can, I'm watching the clock here and trying to figure out how much we can get done between now and then. Senate Bill 190, going back to Delegate Williams. This is Gabriel's law and there's an amendment to conform this bill with the House with what we passed out of the House initially. That's correct, right? Right. There's a motion and a second to conform. Any discussion? Seeing none, all in favor of that amendment, raise your hands. 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Anybody opposed? Nobody's opposed. We're on the amended bill. Motion for a favorable. Is there a second? All right. Any discussion? The Vice Chair? Yes. Munoz is not here. She is excused. Crutchfield? Yes. Cardin? Yes. Sample Hughes? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes, Roberson. Yes, Tomlinson. Yes, Erican. Yes, Taylor. Yes, Simpson. Yes, Grammer. Yes, Moon. Yes, Valentine. Yes, Conaway. Yes, Kaufman. Yes, Williams. All right. Senate Bill 190. All right, now we have three. They're very different. I need to find 190. One moment, please. There's 190. All right. We're going to start with the conversation on Senate Bill 123. Senate Bill 123 is the second look bill that was sent over from Senator Carter. There are amendments that you should have in your packet. And I'll describe the amendments to Senate Bill 123, and they're made by me. What the bill would do as amended is it would offer the opportunity for two modifications of sentence. The person would have to be a person who was sentenced initially in the case, at least 18 years old and under the age of 28. So between 18 and 28, they would be able to file for a modification at 20 years, and they would be able to file another modification 10 years later or 30 years from the start of their sentence. They would not be able to file more than two petitions. The individual would not be able to file a petition to modify if the individual had been sentenced to life without the possibility of parole. A victim in the case may submit a victim impact statement regarding the impact of the crime and the proposed sentence reduction. And it indicates the court shall consider all victim impact statements filed in the case presented to the court at the time of sentencing or under the subsection. The bill as amended again contains the same language as the bill was introduced with regard to the court's decision in the matter. The court would have to decide how they and as part of a written decision that they make, they look at a number of different factors, and those are listed on page 4 of the bill. The bill as it came over from the Senate, just to be candid, included some different language with when it came to who was covered. Also, it also included language that that created a presumption based on the person's age that they were or were not a threat to public safety. We've stricken that language. And so the bill is as I've described it with my amendments. Could I get a motion, please, on my amendments? There's motion and a second. We're on my amendments to Senate Bill 123. Is there a discussion on the amendments? Delegate Carton.
Just first, I think that I just want to make sure I'm clear that you're sentenced between 18, you have to be at least 18, and you can't be at sentencing, and under 28, not 28. So under
28.
Under
So
28.
it's 18 to 28. So
Okay.
27 and 364 days.
And life without the possibility of parole is excluded from the bill.
They are not included in the bill.
Okay.
They're about, we've gotten numbers from the department that indicate, I think it was, and Hunter has stepped out of the room, I think it was 360 people who are life without the possibility of parole. There's 1,600 people who have sentences of life with the possibility of parole or have sentences where the active incarceration would be 40 years or longer. The argument for looking at that threshold is that in a lot of cases, people who have received active sentences for 40 years would start to be eligible for some kind of parole at about 20, depending on the kinds of crimes that they've committed. So we looked for the purposes of finding out that number. Those are the people who we looked at who were held in the Department of Corrections.
And then my final question is, I should have brought this up to you privately, but if you are sentenced at, let's say, 18, and then you decide to file one of these at age
38.
40, but let's say you wait a little bit longer.
Sure.
Say you wait until you're 40, or 45. Do you then have to wait an additional 10 years? Or do you have to wait until it's been 30 years since you were sentenced?
The bill as it's drafted says that it would be 30 years from when you were
So you
sentenced.
could, in
So
theory, you could-
theoretically, you could wait and do it at the 29th year and then do it at the 30th year
Okay.
if you
That was
wanted to. The other, I mean, the argument is we could try and you could try it a different way, but I think the argument is you're getting two chances to get a second look, one after the 20th year and then one after the 30th year. And in talking with some of the advocates, the belief is what is important is that they want those applications to be solid. And so they may want to do that. They may want to come quickly in time between each other, but they want each one of them to count. And so that is why we're not saying it's got to be another 10 years after that.
And lastly, there's a House bill. We're gonna hopefully look at the House bill as time permits.
We are. And the amendments came together for this very quickly. And with respect to Delegate Pasteur, we will move her House bill as quickly as we can, but we need time to be able to make sure the amendments are properly conformed to her bill. And since we're talking about Delegate Pasteur, let's hear from her now. Delegate Pasteur.
Okay, thank you. And even at this hour, I do appreciate Senator Carter's bill being on the voting agenda, but I do have a couple of questions. Well, no, this one isn't a question. Remember, I have amendments that are still relevant to anything that happens to this bill because they are essentially technical ones that are in mine, but are not in hers, but need to be things like from sentence to sentences. So, and you should have a copy of those, should have gotten a copy of those amendments about a week ago. So they do need to be added because they are a part of some of what is still in this, if these amendments were.
So what I would say is I'd be happy to look at those amendments. We would hold it today in order to do that, and it might be wise to do that. I'm happy to take other people's questions and come back to that, but I don't remember seeing those amendments. And I don't know if they conflict with the overall with what I have proposed in this amendment. So I need to look at them in that context too. So why don't we do this? I'm going to go ahead and take questions on where we are right now, and then I'd have to look and see what those are, but we might be heading for a hole. Delegate Sample. Okay, that's fine. Go ahead.
That was a comment. Okay, my question has to do with life without parole. And those people, all 360, were in the original in terms of intent. So, and I know that since we're talking about Senator Carter's bill, that she is very adamant about having them in this bill. So, and we know that because of that which brought us to having life without parole back in the 70s, that there are some people who, let's talk felony murder, just as an example, and some who had other offenses akin to maybe even self-defense, who at the time, because there was nothing to control state's attorneys or judges even, and it was in lieu of death penalty, some of these people were given, and they would be some of my contemporaries or close to it, or a little older maybe, are still incarcerated. So, and you just talk to me a little bit about that thinking, about taking that out, because it wasn't taken out of the Senate's version.
Sure.
And something else was taken out of the Senate's version which.
There are a
put
couple
back.
things that were taken out of the Senate's version, and I want to highlight a couple of the other things that are added. So there's a couple points that I want to make sure that people know were added to the legislation, and then there's a amendment here. Again, the parts that were added include the right of a victim to submit a victim impact statement regarding the impact of the crime and the proposed sentence reduction. And further, the court shall consider all victim impact statements filed in the case or presented to the court at the time of sentencing or under this section. So that means that the victim impact statements, no matter when they were, would be available to the court. It also adds a commission, and I've been in contact, had some contact with the governor's office that would study parole, diminution credits, and other mechanisms for early release that would study the parole process, dim credits, and the governor's ability to issue parole pardons in the state, the process by which the governor issues pardons. And that task force would meet to make proposals as to what comes next. What is taken out of the Senate bill would have removed people who had committed first-degree rape. The Senate said that that universe should not be eligible. The House version would make those people eligible for the modification. It also said it did include people who were who had sentences of life without the possibility of parole were included. Those people, they are almost all people who have committed first-degree murder. And they would be out under the House bill, but they were in under the Senate bill. The Senate bill had a presumption that a person who was 60 years of age, solely based on their age, would not be considered a risk to public safety, and that's one of the points in the bill that the judge is supposed to consider. And so, to that end, we've got. That's basically what the amendment does. It takes out some of the parts from the Senate bill. It adds in the things that I've laid out. And that's what I'm proposing here as part of the amendment.
Okay. All right, I'm a mull for a moment.
Okay, Delegate Sample Hughes.
Thank you, Mr. Chair. And this is actually some of the responses that you have given speak to part of my question. And I've been grappling back and forth with this bill for many reasons, but I just wanted to get clarity on the specific point in regards to the 360 people, life without parole. And I'll wait till you listen. Sorry. You're fine. Go ahead, Mr. Chair.
This Delegate Sample Hughes, I'm sorry, would you repeat your question? I apologize.
Sure. So
Too much.
what I was saying is that initially with this bill, and even for this given moment, I'm still kind of grappling with it, making sure I am, in my personal opinion, making the right decision. But to go back to some of the questions that the delegate was just asking about the life without parole. So is the rationale behind that being in the amendment is to speak to the task force that's being considered, saying, or is it just like a flat out, no, this is something that we're not going to move forward with? That's why you're putting forth the amendment, or the task force is going to hopefully at some point study the entire parole process?
Nothing would stop the task force from addressing that issue. Nothing would stop the task force from addressing the issue of whether people who are life without parole should be addressed by something like this. The way that I saw this was that task force is going to need time to do its work. And so there needed to be a universe of people where we start the work. And so that's why I crafted this in such a way to exclude life without. And speaking for myself, for me, and it's, I have heard from many people from families, and I continue to hear from families of people who are being held on life sentences and life without parole. And I appreciate that they've reached out, and I've had good conversations with a lot of people. For me today, we're on a bill talking about a second look. I think I've given this a bit of a second look myself. For me today, that's not something that I personally would be ready to entertain, but I don't foreclose it as something that the work group might consider in the future. My concern today is that when they were sentenced to life without the possibility of parole, there were victims who were told this person is not going to get out of jail ever again. And I don't take that lightly. And I think that, honestly, I don't think that the bill's sponsors take that lightly. And I mean no disrespect to Delegate Pasteur, who we've had long conversations on this issue, don't take it lightly at all. And she's made me think about this quite a bit. But I think for now, I think that this is a place to start, a place to set up the structure, and a place to consider the more than 1,600 people who could potentially qualify under this for a modification of their sentence.
Okay, so kind of look into that being, or this proposal being like the first step towards additional conversation.
It might.
Or a review, I should say.
It might, yes.
Sure. Okay, thank you.
Delegate Schmidt.
Thank you, Chair. I'm reviewing a letter that I have from my state's attorney. Do your amendments address any of those concerns? I'm assuming you've gotten the same letter, or maybe have had conversation with her regarding the parole board and the chairman of the parole commission's comments regarding the bill.
I do not have a copy of that letter in front of me, but in conversations that I've had with her and with others, she's raised issues related to, and I've raised issues along the way on this issue that I do think that we need. And I think the back of the bill then allows for the creation of a commission that engages the governor in a conversation about where we want to go with issues related to the parole commission itself. I think that we deal with these issues from time to time, and we may continue to deal with these issues because this is it's broadly a difficult issue, but we have a parole commission. We don't always use the parole commission, and sometimes the parole commission, in one of my conversations, had a long conversation about the different ways that the parole commission simply doesn't work. So it's time for us to have those conversations. They're difficult conversations because we're dealing with people who have in the past been convicted of doing really difficult, really terrible things. That's why I think that's an important part of the amendment. We need to start having that conversation. We need to have a conversation about the process by which the governor the governor looks at ways to cut sentences short, and we also need to look at the ways that we deal with dim credits and other credits behind the walls.
I appreciate that explanation. I think some of the concerns that constituents I have regarding someone like the Capital Gazette concern and should that person have a second look?
She raised that issue directly. She tried the case. I've worked under two state's attorneys who were in the middle of trying the Ramos case. And he would not be covered by this bill. He wouldn't be covered by this bill because at the time, I believe at the time of sentencing, he was over 28. When it happened, I think he was 38. So he wouldn't be covered. He wouldn't be covered by this bill.
Fair enough. Thank you for those answers.
Delegate Boucher, going around.
Thank you, Mr. Chairman. This bill presents a bit of a paradox for me, having been the victim of an attempted murder and having someone doing a life sentence for trying to murder me. However, I am supportive of this bill. And it's tough for me to say that, but I think the most important thing out of this bill is for the victims to have a voice at the table during the process when this takes place. And that's all I have to say about that. Thank you.
That's one of the amendments, one of the parts of the amendment that I'm offering. I think it's fairly clear within our existing victim law that victim can submit a victim impact statement, but we're making 100% sure that they definitely can with this amendment, definitely can with the modification, submit a victim impact statement, and expressly saying that the court shall consider all the victim impact statements. And that, in my mind, can be construed a couple different ways because that's sort of what we do in this committee. But I think the presumption that some people might have is that they could be completely opposed both times. One of the arguments that has been made by advocates for the legislation is that over time, there are some victims who change their mind. There are some victims who don't have the same position today that they had before. And so that also gives the court the opportunity to see the victim where they are today as opposed to where they were at the time of. The flip side of that is, if particularly in cases of sexual assault, there are victims who do not want to be anywhere close to the person who engaged in that behavior. We want to provide the opportunity for them to make sure that the court knows what their feelings are, say that the court shall consider those things, and then it gives them the ability not to be there, or just, either to put in a written statement or to rely on the statement they made at the initial sentencing.
Leadership on it. Thank you.
Thank you. Delegate Taylor.
Thank you, Mr. Chair. First, are your amendments all in one big amendment, or are they several amendments?
It's one amendment, and the amendment is number 283529.
Okay.
I have an interlineated copy. I think we provided an interlineated copy to people. It's around every committee should
Okay.
have an interlineated copy of the
So-
bill, as my amendment would create.
Thank you. So that's my first question of several. Isn't it true that if you qualify for a second look, that doesn't mean that you're going to be released? There's going to be
Correct.
some period of examination, some thorough examination of the facts, including possibility this a victim's impact statement. So why would we pull out the life without parole folks if there's going to be a careful examination? I would think that maybe the percentages would be lower for those that would be released, but I'm pretty sure there are some instances where there are life without parolees that have been convicted in error, that were just in the vicinity, or, not really the ones that pulled the trigger, that potentially would qualify, and after careful consideration of their cases would also be released. So I would love to see the LWOPs kept in this bill, which is why I asked, were your amendments separate?
The amendment that I've offered, again, is all together in one.
Got it.
And I respect that. I respect what you're saying. I believe, and the reason that I put together the amendment in this way is that this is a place where we can start this conversation. It's not going to be the end of the conversation.
Sure.
I do think that there's a different conversation that happens, as I said, with regard to life without the possibility of parole. I think there's a different conversation with that universe
Sure.
than there is with other parts of the universe. It's not an easy conversation to have in either case.
Right.
But I think that for today, where we are and where this bill sits, I think this is a place that we can start.
Mhm.
And then we can go from here and see what the commission says and begin to have that conversation in days to come.
Awesome.
You
May I
had
ask-
another question. Go
I
ahead.
actually have several, if you don't mind. I'm trying to understand the age range. So my first question with regard to the age range is, if you were 17 and convicted as an adult, you don't qualify? Or do you?
So they would be covered under the JRA. They would be covered under the juvenile bill that we passed in 2021. This is based on legislation that was passed when you were not here. All right,
Right.
so let's start with that. So there were juvenile people who were convicted to life. They were convicted to life sentences, and they were convicted when they themselves were juveniles. And so that they'd be covered under that legislation, so they wouldn't have to be covered under this legislation.
And they have a second look engineered into there.
They have a
somewhere?
second and a third look engineered in.
Okay, and then what happens to the folks that are over 20, that are 29 and above now?
It would be from 28 and 1 day, and 28 and no days, and over, they would not qualify for a modification under this. I asked for information from the Department of Public Safety as to how many people we're talking about. It's a little more than half of the people who are sentenced to life, or to life with the possibility of parole, or to a sentence of years where the sentences, they may have been convicted of multiple crimes and they are consecutive to each other. The sentences are consecutive to each other, and it totals more than 40 years of incarceration.
So under this amendment, they wouldn't qualify at all for a second look?
They would not qualify under this for a modification of 20 or 30 years, correct? This starts with the universe of people, and the reason that we contacted the department was to make sure that we were dealing with the universe of people that is the majority. It is the majority of the people who are being held for life. And I felt that there was a difference between people who were sentenced when they were younger and people who were sentenced when they were, say, in their 50s. That's a different, that I think there's a difference between those groups of people. Again, the reason for the commission at the back of the bill is to look at these issues going forward and to figure out what comes next. But for now, this would be the universe of people who would be able to use the modification.
And the way the bill is now is that it's 20 years. After 20 years served,
They
and
could request
10
their
years
first.
for the second look.
Right.
Or
So
the second.
So 30, so effectively, they could theoretically request them back to back after 30 years because they would qualify for the first one after they served 20 and then the second one after they served 30. If they chose to wait before they sought their first modification until the 30th year, they could certainly do that.
Great.
But it provides at least some flexibility with that.
I got it. Thank you.
Thank you. Delegate Conaway.
Mr. Chairman, this would be retroactive? In other words, if a person's already served 25 years right now, then they could qualify for the second look without your amendment?
Under my amendment or not, they one way or the other, this is retroactive. This would go back, this would apply to people who were sentenced prior to the time that the bill becomes law. So as long as they had served at least 20 years of active incarceration, they would be able to use the law.
And what is your amendment going to do?
It doesn't change anything with regard to who can in other words, it's not prospective. It doesn't say that only the people who are sentenced after July 1st can or whenever the effective date of the bill is. Only the people after that time could use this. It would be anybody who is presently under a sentence where they have served at least 20 years of active incarceration.
But your amendment is going to do what to the bill?
So what my amendment says is that the modification could be used by people 18 to 28, and it would not be available to people who had been sentenced to life without the possibility of parole.
Right. So my point is, the point I was trying to get to is you made some comments and I got to thinking, or I began thinking about 40 years ago or the social environment 20 years ago.
Sure.
And while I today might be in agreement with a person shouldn't be able to get a second look back if they got life without parole today, looking back 20 years ago or 24 years ago, let's say in the time of Reaganomics, the atmosphere was totally different.
Yeah.
When you look back to the time of Martin Luther King, I thought to myself, that atmosphere is just totally different.
Sure.
So therefore, that would change my opinion today And I would think that a person should get the second look.
Well, and I think that this, at least in part, the amendment is seeking to go one of the steps that we need to go. If that's your position, that's fine. And that it's seeking to take one step forward and then have a conversation about how these should be fitting in to the larger process, how it should be fitting into the parole commission, how it goes to the governor's work on pardons, how it goes to dim credits, and how we talk about all of these things. So the goal here today is to get something.
Is to get one step and then
Is
we
to take one
go to
step.
the dance. I got you.
Yes.
Thank you very much, Mr.
Now
Johnson.
back to Delegate Pasteur for a second.
Okay, thank you. And I appreciate your letting me do this. And the question is going to be, may I say this? Because I really need to say this. And I need to say it not just to you, because we've had so many conversations. I know that you've been thinking about it, but I want to say this to people in this room, young and old. I don't need anybody to tell me about being serious about race and injustice. I am over 70 years old. I know what it means about racial injustice. I don't need a soul in this room to tell me about it. I've lived my life with it. So I'm looking for a way so that younger people don't, one, that's why I was an educator, have to relive the nonsense. And this is why I give him a hug. I told him once, do you know why I just sometimes just walk up and hug you? It's because I need to ground my soul, because it would be very easy for me to be a mean, angry, as they say, Black woman. Because I have the marks, you see it? Do you see it? I have the marks on my body from having been abused. I have people down here who have said outrageous things. I've had to have bodyguards to walk me into a school board meeting. So I don't need anybody to tell me about race and the injustices. I get it. I lived through, as a grown-up, or close to it, while this bill to get rid of the death penalty was formed, and this is how we got life without parole. And we watched, I didn't just watch, I was on the street with my parents who were proactive, who got out there to say, we are not going to accept this quietly. Now, you know what? I don't understand down here, and I've grown to not like a whole lot of people, because I'm an elected official, not a politician. And so all of you who play the politician thing, because I can be very graphic, that's what you can do for me. Because this is about people's lives. Like the delegate, like Conway just said, we know that some of the contemporaries are still in prison for things they should have never been arrested for in the first place. That's a fact. We know that there are young people who get it piled on, and some judge get the wrong judge who just lays out a whole bunch of years in life just because they think they're taking, yeah, I'm gonna go there, one more Black child off the street. Understand, we're not just talking about Black males, we're talking about females. When you want to know why our communities are being decimated, it's because they're sitting in prison or they're sitting somewhere with their minds messed up. I remember being in the FBI, having to talk about in class the decision to help guide the mafia into Harlem and places like that for control. Enough is enough. If you had done my bill first, we would be in a different place. Because had my bill been done first, the House bill done first, I would be the one sitting and working and having the last word about where we should go and how we take the steps to grow. Because see, some people now have lived long enough in this world down here in Wonderland, where they believe even whatever is, what's the chair of your, what's his name? The guy across the street, Smith.
Oh.
Okay, sat there and said, and talked about how we come up with these big bills and don't follow through on. I like the people that you've put on this committee. I like what some of the things you have done with this, but he said we don't follow through. So now we have believers out there who think if you have a task force, we are not going to follow through on it. Well, damn it, I said it on the floor and I'm gonna say it now. And I guess I just said it on video or live stream or whatever. Okay, because you know, I don't understand any of that, but I can barely use the phone. But I'm saying, I'm going to make sure we do. But the LWOPs, yeah, they do deserve a second look. Especially if they've been in there for a long time, because they were put in there when people were not really being judicious, and race did fall right at the center. But now I'm in a quandary because my bill didn't come first. And I couldn't just speak for me, because today I have to speak for the senator. And the senator's clear that she does not want this amendment if LWOP is not going to be in there or addressed in some way. And that means we have over 1,100, 1,200, whatever, people who will be disenfranchised a friggin' second time, because the bill will probably go nowhere. And they will be disenfranchised for 360 people that if we all the groups represented out there who are, let's step up and fight for those 360 some. See, that's the same thing we've been doing. We get so used to the system telling us what to do, we just give up. I mean, I almost said it again. I won't say that again. I'm not going to give up. I will fight members of the group, anybody that's involved. This is important. This will rebuild our communities. But I have to right now, because it's the senator's bill. I'm going to vote, but it's my vote. I want you to listen to what I had to say. I'm going to vote because this charge was left on me. But I'd rather that you listen to what I have to say. Otherwise, we will be prisoners 20, 30, 40 years from now. And I don't want to die. I lived through this. And I don't believe that my God brought me this far. I've been a victim. And the chair and I talked about this, that when I was 22, and I never say this, but I must say it to anybody that's watching it. When my first husband was in the midst of trying to kill me and had a weapon, and I happened to get my hand on it, and my thought was to take him out. But the word of God came to me and said, put it down, I've got you. And none of you can mess with that. You can talk about me, not like me. I have all the friends I need for the rest of my life. But the word of God told me to stop, and I did. And did we not agree that back then when I was 22 years old, I would have been incarcerated? Nobody would have cared that it was self-defense. And somebody would be sitting in here now talking about whether I should get a second look. Little school teacher. So I'm going to vote because this is my responsibility. But you have a bigger responsibility. We have a big responsibility to a bunch of people who have been disenfranchised. And we're going to keep raising children in our schools who will be, if we're not careful, further disenfranchised. But I've had enough. And I thank you for letting me say all of this, but I've really had enough. I'm tired of the politics. I can go home next week and not have to come back here.
Amen.
And who I am is who I became long before one person casted a vote for me. And that's my reality. I don't have to come back and continue this nonsense where we pick and choose based on our lives, how other people are going to live and just throw it up in the air. Thank you. I really am done. I'm so done. I'm like the Thanksgiving turkey.
All right. Thank you, Delegate. I don't for a moment question I struggled with, and he's sitting here in the committee room today. I struggled with Delegate Lewis's bill. I struggled with Delegate Lewis's bill, one of the first bills that came before me as a new chair, and struggled with that, and struggled with what victims were saying, and struggled with the challenge that exists in the possibility of redemption. And when we ultimately passed that bill, the bill was legislation that I took to the floor, and it was not a pleasant debate in any way, shape, or form. It's a hard issue. And so what I have tried to do with this set of amendments is find a way forward on an incredibly difficult issue to make sure that there is legislation that can get its way all the way across the House and find its way, hopefully, to the governor's desk, so that we not only can address the issue of a significant number of people who are covered by by at least by this amendment, but also to take a thoughtful look at how we should be addressing this situation going forward. It's not easy to do. It's never easy to do. And the passion of the people whose family members have been behind the walls for for all of their adult lives is real. And I hear it. And it's not easy for me to, in any way, and I struggle with it, honestly, because it is not in any way easy for me to figure out and try to discern the best way forward. But I will say to the members of this committee, in this amendment, I'm trying to find the best way forward that can move this bill forward and can hopefully be signed by the governor and allow us to continue this conversation and continue to look at the people who have been detained for long sentences. Are there further questions for this amendment? There are several people out of the room, and I'm not going to call a vote while they're still out of the room, because I know that Delegate Pasteur is taking a moment, and so we may just hold this anyway. But are there further questions at this point on this bill? All right, give Delegate Taylor.
Well, since we're gonna wait to vote, I thought I'd just ask another question. Well, this bill has already passed out of the Senate, right? It's come out. We got a bill from the Senate. Why wouldn't it come out of the House if we pass it out of this committee? What's stopping it from,
It
I mean,
doesn't.
why do we have to make it so radically different in order for it to come out of the House?
I've heard from a large number of people and I'm trying to take their concerns into account as well as others and try to figure out, again, the best way to go forward. All right, Delegate Williams.
I will say with the version that came over in the Senate, I did express some concerns about the Senate version. I felt like there should be an opportunity for more than just one opportunity for individuals who would fall within the bill. I think that what's called the second look, we should give them at least at least two opportunities in which to file a petition with the court. The version that came over from the Senate, if I believed, only allowed sort of one opportunity. I will admit, wasn't comfortable with just the arbitrary number of 60 years. And I did express maybe just making a duration. I said 5 to 10, but we have 20 now. So, there's that. But at least some type of scheme that would allow individuals to be able to apply at least more than once. I know I'm not the same person today that I was when I was 18. And I do believe in redemption. And so I thought it was important for people to have that opportunity. And that was something that I know I expressed to the chair. I know he's not going to say who expressed what to him, but I will admit that I did express that to the chair. And that was one of the reasons you see at least that change. To help answer part of your question, Delegate Taylor.
Was 20 and 10, wasn't it? Is that right?
It's 20 and 10
Okay.
because the first option would be at 20 years and then the second option effectively would be at 30 years. So it's a little variation on 20 and 10 where it could conceivably, you could make it 29 and then 30, but it allows for it could be 29 and 39. It's up to the person who's filing the modification.
But if you're my age, 23, no.
23.
If you're my age or let's say you're 50, then you're not covered. Okay. If you were sentenced at 50, you're not covered. Okay. But you've been for 30 years, so now you're 80.
So now you're 80.
Then you're still not covered.
You would not be covered under this amendment. And the argument that was put forward first is that, okay. The argument that was put forward was that somebody who commits one of these serious crimes at the age of 50 is different in a lot of ways than somebody who has committed one of these crimes at 20 or what have you. It's if they're in a different position.
Yeah.
Delegate Moon.
Are we voting today?
Let me see if I can get this.
We're going to the floor here in a second, I think.
Are we voting this bill today?
Well, so the challenge is, and I'll just say procedurally, the issue here is if this bill is going to continue and come in and be able to make it forward in any form, then this is probably got to get moving here in the near future.
Okay, well
in the
then,
very near
Mr.
future.
Chair, I'm going to move your amendment. I know some of the advocates are very disappointed in this, but at this time of the year, and I know it's politics, but politics is also part of how we factor in making the law here. And this bill has been around since my first years down here. We've been trying, many of us, to get many aspects of the parole and early release system in place. I thought we had some of it moving 2-3 years ago. It moved in one chamber and died. And here we have another opportunity to reopen the door. And I know folks want more. we are running out of time. If we don't get this thing off on the floor today, I think we're really cutting it close. And there are some significant advances that we would see in this bill helping a lot of people. And so unfortunately, I'm moving the amendment.
Delegate Phillips, did you want to say something?
Yes, I just want to, I was moved by my colleague, and you and I have had a personal conversation. We are not necessarily the same people today that we were in our teens. And at the end of the day, I think we need to address this issue and continue to push this issue. I believe it's important that we move as Delegate Moon has suggested. I do believe the stars are aligned to at least get this done in 2024. I know this will disappoint a lot of people. I know a number of folks have come to me to lobby and to argue that we must have LWOP in it. I will promise those that we will continue to fight, but we need to move today.
There's a motion on the table for the amendment and that amendment has been seconded. Is there any? So we're going to give just a brief moment to give people a chance to come back into the room. And we're going to let people come back in, and they're aware on the floor that we are giving them a moment to come back into the room. So if we could just have a moment, I'm not going to adjourn us, but I'm just going to ask the committee's indulgence just for a moment so that we can make sure that everyone's in the room. So just one moment, please. Right. The amendment again is on 283-529. The amendment is before us. It has been seconded. All in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. All those opposed? 1, 2, 3, 4, 5. 17-5, the amendment is adopted. Delegate Pasteur, you've indicated and you provided a copy of the committee, and I've just received it, and Claire has reviewed a copy of the amendment that you provided. And what I will say to the committee, do they have this as well, or I want to make sure they don't have this? They do not. Okay. Kind of at a place where we've got a kind of running out of time here. If I'm happy to make an oral motion, if the committee is comfortable, and I'm going to go through what the amendment would do. For the record, this was an amendment done to House Bill 724 that is 293-721. And I'm looking at Claire a little bit so that she's aware of what I'm going to do is what this amendment would do. It first adds the title, the Maryland Second Look Act, to the bill. It just adds the title inside the bill. It in several different places in the bill, starting in 8501 of the code, it would say, right now, for example, the bill says, except as provided in paragraph 5, under the amendment we just passed, except as provided in paragraph 5 of this subsection, and notwithstanding any other provision of law, an individual who is serving a term of confinement may petition the court to reduce the sentence if, and then the bill continues. What Delegate Pasteur's amendment would do is wherever it refers in the bill to the word sentence, it makes it sentence or sentences. And because the amendment that we passed changes the points in the bill where that is, first, as I read the newly amended version of Senate Bill 123, by adding sentence and sentences to each one of those places, it's consistent with your intent within the amendment. The other thing the amendment does is it indicates that a petitioner under this section is entitled to the assistance of counsel, and if indigent to representation by the Office of the Public Defender, that would be included into the legislation should this amendment pass. And then I'm just making sure I didn't. One moment, please. Let me just make sure. In the amended version, on page 3, section C, it says, if a hearing is held under this section, the court's decision regarding whether to reduce the petitioner's sentence shall be on the record in an open court at the hearing. The amendment would make that in a hearing, if a hearing is held under this section, the court shall state its reasons for its decision regarding whether to reduce the petitioner's sentence or sentences. And it says it would be on the record and in writing within 90 days. Makes a couple, it basically makes a couple technical changes to that part of the legislation. I believe that those are all of the amendments that I more than believe. I've literally gone through the amendment and cross-referenced it with the amended version that we just passed. And I believe that adopts the changes, most of them technical, to it basically allows for the Office of the Public Defender to work with a person who has been who would be filing a motion under these cases. And I certainly don't have a problem with that. Delegate Kaufman.
Does the chairman have a recommendation on this amendment?
The chair would support the amendment.
Thank you.
There's a motion for the amendment and a second. Claire, are you okay? Yeah, Claire is okay. All right. Delegate Conway.
Amendment is on the House bill?
It's on the House bill.
Yes, thank you. That's good.
So,
That's good.
yeah, and that's why I had to take a second, and because I'm cross-referencing it back and forth, and I'm wanting to make sure that we get the spirit of what Delegate Pasteur was doing on into the amended bill. All in favor of this amendment from Delegate Pasteur, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, or 19. Holly can't vote. Anybody opposed? Seeing none. We're now on the bill. What was your question? And then
About the eligibility for the public defender. In this situation now, are they eligible for the public defender in post-conviction
They
matters? Or
almost-
is this an
this would add
additional-
to that.
They're,
Yes.
they're low, they're precluded.
They would qualify without question because they're
Correct.
indigent,
But
but
it's
this
not
allows
matters-
for that.
It's
Yes.
not matters they're handling now.
Yes, correct. All right, on the bill, there's a motion for a favorable on the bill as amended. Is there any further discussion on the bill as amended? Seeing none. The vice chair. Yes. Crutchfield. Yes. Cardin. Yes. Sample Hughes. Yes. Embry. Yes. Pasteur. You've absolutely.
I promise. I just wanted to see this bill move forward and not die into the great abyss. But to those who voted, we can always know someone who's a LWOP. That's a new sound. And we must begin, like when we get out of these chairs, to start that fight to make sure that those who are incarcerated under that are equitably incarcerated, and those who deserve a second look should get it, that we don't fear the past. We work for the future and the present. That's why I voted this way.
Delegate Tolles. Yes. Schmidt. No. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. No. Erican. No. Taylor. Yes. Simpson. Yes. Grammer. No. Moon. Yes. Valentine. No. Conaway. This is Senate Bill 123. Yes. Kaufman. Yes. Williams. Yes. The House bill has to now be amended to conform with this, and I'll try and get us back here after the second session to do that. All right, thank you. We're going to stop right there. Thank you very much.